Chairman, I acknowledge the ranking member and the chairman of the Important Oversight Committee and the work that they do to ensure that government agencies work well. As they do so, I would expect that their efforts would meet all tests of credibility and as well the four corners of the Constitution. I've tried to study this legislation. However, it concerns me again because it would make it more difficult for government agencies to share pertinent information with important stakeholders to keep our country safe. With no clear exceptions for national security, this legislation would add burdensome and unworkable reporting requirements and a 72-hour waiting period, which could be detrimental to our democratic institutions during times where communication is necessary to protect our democracy. This bill is seeking to limit the lawful activities of federal law enforcement agencies, and it is a threat to our national security. All of us stand on this floor and stand shoulder to shoulder with law enforcement. Our firefighters are here on the campus. We stand shoulder to shoulder with them. But I'm afraid, Mr. Chairman, this legislation would not show our confidence in those who have to do the job. And so I offer an amendment that provides a response to the section on severability that keeps the remaining portions of the Act in place should a portion of the Act or an amendment made by the Act be held to be unconstitutional. The insertion of such a severability clause in this bill is telling of the complete lack of faith, I believe, in the constitutional viability and credibility this entire bill aims to put forth. While the general purpose of the severability doctrine clause is used to direct courts on what to do with a statute or a part of it if a provision is invalidated, Congress actually is discouraged from using express severability clauses, given it is unnecessary due to the court's strong presumption in favor of any such need for severability. Moreover, Congress assumes its laws are constitutional. This should be constitutional. As such, the primary application of a severability clause is for the functionality of the statute and whether the surviving provisions are capable of functioning independently. This is not a free speech. You are denying our federal officers free speech to do their job to protect America. And so to include a general severability clause in H.R. 140 is not intended to provide clarity to the courts on specific sections of this bill, but rather it is an ill attempt to save a poorly written bill and one that steps on the First Amendment rights of our hardworking patriots, our federal employees, because it is anticipated that this bill may be held unconstitutional. I ask my colleagues to support the Jackson-Lee Amendment, and I reserve my time.
Gentlewoman reserves. For what purpose does the gentleman from Kentucky seek recognition?
I rise in opposition to the amendment.
The gentleman is recognized.
This bill is timely and necessary. We have learned just how easy it is for the federal government to influence a private company to limit the exercise of First Amendment protected speech. During a recent hearing on the Twitter files, the Oversight Committee heard from a former FBI official and Twitter employee who called for federal legislation that would reasonably and effectively limit government interactions with private sector platforms. Let me be clear. A former FBI official and former Twitter employee endorsed and called for legislation just like this. This legislation should not be controversial, but the intention of this amendment is to gut this bill. The intention of this amendment is to risk the implementation of this necessary legislation. The inclusion of the clause this amendment removes is standard legislative practice. All this clause does is make sure that if a court decides to strike down any part of this act, that the rest of the act stays intact. It's that simple. These clauses have been used in legislation for decades, including a clause like this one in this legislation is standard practice that ensures that this much needed and non-controversial legislation can be faithfully implemented. I urge my colleagues to vote no on this amendment, and I reserve the balance of my time.
The gentleman reserves.
How much time do I have remaining?
The gentlewoman from Texas is recognized with 2 minutes.
I'm pleased to yield 30 seconds to the gentleman from New York, Ms. Golden.
Thank you to the gentlelady from Texas. Just briefly, we were at that Twitter hearing when the former general counsel of Twitter and of the FBI suggested that there needs to be legislation in order for social media companies to properly coordinate with law enforcement. And we wholeheartedly agree. I am certain that he would never in a million years imagine that this would be the legislation, because this completely guts the FBI's ability to protect the safety and security of the American people and our democracy. So let's not insinuate here that a former Twitter employee wanted this bill
Gentleman's time has expired.
To be the legislation that we need.
10 seconds.
Thank you. Let's not pretend that the witness at that hearing wants this bill to be the legislation in order for social media and law enforcement to coordinate. I'm happy to work with the chairman on that, but it is not this bill. I yield back.
Serve.
Gentlewoman reserves. Gentleman from Kentucky is recognized.
I yield back the balance of my time.
Gentleman yields back. Gentlewoman from Texas.
First of all, let me thank the gentleman from New York for his clarification. He was in the hearing. He heard the witness ask for relief. But I would say that that gentleman did not ask to have at the core of the relief a legislative initiative rooted in far-right conspiracy theories, despite the clear lack of evidence that any Biden administration official violated the First Amendment or censored Americans or social media platforms. We want to work with making sure that we are safe and have national security, but at the same time, how are we going to amend the Hatch Act and really shut down those who are involved in law enforcement and national security? We saw what happened on January 6th. We need all of the communications and intelligence that we need, not only to protect our law enforcement, but to protect the United States of America. So my amendment is necessary, Mr. Chairman. It is necessary because the court's presumption is that the statute is constitutional. So if there's a section that is found unconstitutional, the court will yield to this idea that they will look at it in a matter to discern what are the facts. My amendment simply says that to put this in the legislation, you are then going to have a guardrail against this bill being found unconstitutional. And so with that in mind, I ask my colleagues to support the Jackson-Lee Amendment, which is a clear expression of the law.
The question is on the amendment offered by the gentlewoman from Texas. Those in favor say aye. Aye. Those opposed say no. No. In the opinion of the chair, the noes have it. The amendment is not agreed to.